Hey everyone, Joe Gentili from Sarov Gentili LLP. Want to go over a recent decision from a judge in federal court in California, and it has to do with Title 42, which was a rule that I believe was originally put in place by the Trump administration, but the Biden administration was also implementing it. And the purpose of the rule was to reduce the amount of people that were applying for asylum. And so, what the rule tried to enforce is to say that if there's a couple of main points. So, point number one is that if you cross the border and not through a port of entry, so you just went through some place where you're not supposed to cross, that you can't apply for asylum if you do that. Second thing is if you pass through a third country and you don't apply for asylum in that country, then you can't apply for asylum in the United States. So I'm oversimplifying it, but basically it was an attempt to make it harder to apply for asylum with people to reduce the numbers. And the judge in California ruled that the Biden administration couldn't do that, that the asylum laws as they are in the books in the United States don't have those requirements in place for people to apply for asylum. So therefore, Biden administration can't put it on people. So if this ruling holds, I assume the Biden administration is going to challenge it. But if it holds, and I think it probably should, I think the judge was correct that these additional requirements that the administration were putting on, they're not allowed to do that. If it holds, you're going to see an increase in the number of asylum applicants. And that is going to result in some knock-on effects to people that have already applied for asylum. So if you've already applied for asylum, one thing I'm sure you're very aware of is that there are very long backlogs in terms of getting the case processed and even getting an asylum interview. And given the current policy that USCIS has of last in, first out, meaning more recent asylum applicants get priority over older asylum applicants in terms of getting an interview. If you have more asylum applicants coming on all the time, it's going to make it that much more difficult for the people that already filed, and in some cases have been waiting 5 years, 6 years, 7 years to get an interview. So what has been a very difficult problem is in all likelihood about to become much worse. The government can fix this by increasing their processing capacity, and there's solutions that the government can do to address this, but given the amount of gridlock that exists in the system on immigration, I don't expect that to happen anytime soon. So the takeaway is that for individuals that are stuck in this backlog for a long time already, the mandamus lawsuits are going to become that much more important to bringing this process to a close, getting an asylum interview, and eventually getting a decision. The backlog probably gets worse from here on out, and especially since they're prioritizing earlier, or I should say later filed cases, it's setting up a system where at least theoretically older filed cases never get an interview. And the only way to break that, unfortunately, is going to be with a federal lawsuit. So yes, that can work for the individual, but the real fix for this problem is going to have to come through the government and Congress changing the system. There's going to have to be much more resources put into processing immigration cases overall, but asylum cases especially, because the backlogs are just too big and they're only set to get bigger. So for individuals, if you're stuck in this position, obviously you can't on your own change the politics of it. So your solution is likely going to be to file a federal lawsuit to get your case decided. However, the big solution, it's going to happen at the political level. So anyway, that's my take on this recent development in asylum law. I hope everybody found this video useful, and if you have any questions, please feel free to reach out, and hope you subscribe for future videos. Thanks.